Hey guys, and welcome back to today's video. We've got two sovereign citizens facing off in two completely different courtrooms, and the second one is a major update to a case we've already been following. So you already know it's about to get messy. But first, we're heading straight into Judge Shackelford's courtroom, where today's sovereign citizen isn't just repeating the usual script, he's literally reading it word for word from a sheet of paper off camera, like it's a rehearsed performance doc. So let's begin.
All right, Mr. Page, this is 242804, the City of Taylor versus Zachary Page.
And good afternoon, Your Honor. For the record, Matthew Sick for the people.
Okay, and I have a note on here. The people are requesting the case be set for a jury trial, and the defendant wants to fire the MIDC attorney. Is that accurate? Mr. Page, are you asking to represent yourself?
Yes, Your Honor. I'm representing myself.
Okay. Okay, you have a right to represent yourself, but I want to make sure you understand this, Mr. Page. You have a right to do that, okay? But you understand that attorneys go to law school and they study the rules of evidence. And if a person who is not a lawyer wants to proceed in a case, they're held to the same standard. You have to play within the same rules as a lawyer when you represent yourself. Do you understand that?
Yes, ma'am.
Okay, Mr. Page, I want you to see this. This is the Michigan court rules. This book is the rules that govern how we do trials, how evidence is admitted, how questions are asked, how trials proceed. And I'm going to assume you've not studied that book. Do you understand that if you go to trial and you represent yourself, that you will be held to the same standard and will be required to comply with those rules?
I understand.
Okay, is there anything else you want to put on record?
Yes.
All right, go ahead.
I, Zachary Page, lowercase a-h-a-r-y, P-A-G-E, a living man and one of the people of the Constitutional Republic of Michigan.
Oh, you can immediately tell this guy is brand new to the sovereign citizen routine. Not only is he stuck reading his little manifesto off a script, but he can't even pronounce the words he's trying so hard to sound smart using. And just for the record, it's not sui juris, it's sui juris, which in his case, basically, translates to professional crayon cruncher. And this is exactly where the whole performance starts to fall apart.
I am the beneficiary of the trust established by the U.S. Constitution and the Michigan Constitution, which operate as trust agreements. Under these trust agreements, public officials act as trustees and are bound by their oaths of office to serve the people, the beneficiaries. Their primary duty is to uphold and protect the inherent and unalienable rights of the people as mandated by these constitutions.
Okay, all right, Mr. Page.
I have more.
I know, you can submit it in writing. I've heard it all before, sir. If you want to be a sovereign citizen today, that's fine with me. All right, but we're going to get through this court proceeding, and I want you to know you're going to behave at trial. You are bound by the laws of the state of Michigan, and that's how we'll be proceeding. So, sir, as to arraignment, how do you plead? You can plead guilty, you can plead not guilty, or you can stand mute.
Could you repeat
Okay.
the last part, please?
You could stand mute. That means you don't say anything and I enter a not guilty plea for you. So a guilty, not guilty, or stand mute.
I'm pleading not guilty to.
Yeah, this is clearly someone who Googled how to get out of jail free at 2 a.m., clicked the first sketchy result, and decided to recite it in court like it's a magic spell. Because a real sovereign citizen, aka one of those sui juris, geniuses they love calling themselves, especially once they're already locked up, wouldn't be doing any of this. They wouldn't plead to the charge, and they definitely wouldn't stand there trying to play mute like the court is supposed to freeze and glitch out. He's not in control. He's just reading nonsense and hoping the judge forgets how reality.
Enter a not guilty plea on your behalf. Sir, I have to go over a few things with you to make sure you understand them, okay? You're charged with interference with police authority. There is an allegation that on November 4th of 2024, while traveling southbound Telegraph near Brest Street in the city of Taylor, that you engaged in behavior that obstructed or interfered with police authority. That is the allegation against you. This is a misdemeanor. It is punishable maximum by up to 90 days in jail and a fine of up to $500. Sir, you have the right under the Constitution to have a trial by a jury and to have the assistance of an attorney. And you have a right to an attorney appointed at public expense if you are indigent, meaning you don't have the money to pay for an attorney. And if the offense requires a minimum jail sentence, there is no minimum jail sentence on this case, or the court determines it might sentence you to jail. It's my understanding that you have waived your right to a court-appointed attorney. You've already put that on record, and you intend on representing yourself. You also have a right to a trial, and at that trial, you have the following rights: to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. And if you chose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. You also have a right to be presumed innocent unless proven guilty beyond a reasonable doubt. Those are your rights under the United States and Michigan Constitution. Do you understand what I just read to you, sir?
I definitely understand her, because Judge Shackelford doesn't look like a bridge. So I'm not sure how anyone is standing under her either dot. And honestly, it was right here that I realized something hilarious. I know sovereign citizen arguments better than the sovereign citizens do dot. So that's basically the end of the first video. The rest of the hearing was a whole lot of nothing. Judge Shackelford just kept it moving and issued him a new court date. Now for the second hearing, we're jumping to a sovereign citizen I've covered recently out of Thurston County, Michael Valentine.
So Mr. Valentine, would you unmute, join us, or if I remember correctly, you'd like to be referred to as American National Valentine?
Present.
Okay, and is that how you'd like me to refer to you?
Yes, ma'am.
Okay, I didn't remember that. So, sir, there was a warrant issued for your arrest back December 6th. You had posted bond on the previous warrant. We had a hearing, and that's what we're here about, is we're still pending trial. And you weren't, the pretrial services violation, that's right. We've got a positive UA from November 1st for THC and cocaine, November 20th, a dilute one, but concerned about THC and cocaine, November 22nd, a UA positive for cocaine. So that's why we're here. And I remember in the past that you were representing yourself. Is that still your intention?
Yes.
Okay. So let me turn to the status to this warrant issue, and then I'll turn back to you. And Mr. Weston?
Your Honor, this time the state would be asking that the current bail be increased to $10,000. It was previously, the state previously asked that amount at arraignment. The court previously imposed $15,000. That somewhere throughout the process, the court decreased the bail to $5,000. He posted the bond for that amount, and which I believe he was released on October 29th, and within a month we have all these pretrial violations. And so the state has substantial concerns about him not following the release conditions that he's required to follow, especially being especially being on pretrial release for DUI. And so the state's asking that the court impose $10,000 bail at this time, and that he either posted or turned himself in.
So, Mr. Valentine?
So I object the state motion. The release conditions that were set were not returned. Ooh,
I can hear you. I can.
okay. Yeah, the release conditions that were set were not returned to its original state. The release conditions were only changed because the 3 charges were added. And once the 3 charges were dismissed, our release conditions were supposed to be returned to personal recognizance. There was other individuals when I was in custody that were in the same situation. The state brought charges against them, but the state didn't have the physical evidence yet, and they released those individuals on their personal recognizance and waited for the results, for the evidence to pursue those charges. But with me, the state is being prejudiced and tried to keep me with strict release conditions, even though the charges were dismissed.
I think maybe, just maybe, that has something to do with your refusal to acknowledge Washington state law and the jurisdiction of this court. Because here's the reality. Bail is subjective. It exists on a range, and it can vary wildly from one defendant to the next depending on the charge, history, risk level, and the facts of the case. But bail itself isn't some magical constitutional right, the way these people try to claim. The Constitution doesn't guarantee you bail. It only protects you from excessive bail under the 8th Amendment, and that protection exists to prevent unfair detention, not to hand you a free pass to do whatever you want while you're waiting for trial on a DUI.
Right. I'll come back to you, Mr. Valentine, but let me ask that particular question of the state here. So is the state ready to go forward to trial? You have all the evidence, all the discovery on this matter, or is there toxicology reports that are pending, or?
Based on my knowledge, Your Honor, there's no blood draw in this case. The state is ready to proceed. It was American National Valentine that did request the continuance of trial confirmation on 11/8.
So you've got everything. You're
Yeah,
not
we got
waiting
everything.
for tox reports. Okay. All right. So back to you, Mr. Valentine. Anything else? Or, I'm sorry, American
Yes.
National Valentine.
The state was awaiting the toxicology report for case number 4A0027328. Those 3 charges that were added on to the case was the reason why I was in on the ankle monitor and working with friendship services. And so since those charges were dropped, I'm only on the case for my DUI, my first DUI. I never had any previous DUIs. This is my first DUI. I was only brought into custody for the extra charges that were added on, and those charges were dismissed. But the release conditions were never changed.
So
Even my
this
bail,
one-
they didn't even lower the bail. I had to argue with the court just to get the bail lowered, even though the charges were dismissed.
So this one is alleged from November 13th of 2021. And then I see that there was a January 1st of 2024 that was dismissed. And now it looks like that has been refiled with an arraignment date scheduled for January 14th. Don't know if you've gotten that in the mail yet
Yes,
or
I
not.
have.
Okay.
Yes, I have.
So, all right. So you're right. These conditions are only about the case alleged from November 13th of 2021. Gotcha. All right. And that's the court order on that matter. 1A730693 was the pretrial services requirement and the requirement of sobriety. All right. So you're saying that, and tell me if I'm wrong, you're saying that I should release you, set this on for trial, and what about conditions of release?
So the conditions to release, I should be back PR'd as I originally was with this charge. If on the other case, like how you said the case was refiled, it's going to be in January. If the state wants to set, release conditions for that charge, that should be done on that case. But they're 2 separate cases now.
But not really. Under normal circumstances, that argument might actually make sense. You were on unrestricted release for the original charge, and your pretrial conditions only got modified because you picked up a second charge one that was eventually dismissed. So on paper, yeah, you'd assume the court would just reinstate your original unrestricted release while you wait for trial. But that logic only works in a vacuum because it completely ignores two huge problems. First, the state has already decided to refile the second charge, the same one that triggered your bond modification in the first place. Second, while you were out on bond, you showed zero respect for the court's conditions by continuing to use illicit substances. So at this point, it doesn't even matter that the second charge was dismissed, refiled, paused, or brought back again. The court isn't punishing you for paperwork. It's holding you accountable for what you did while you were already given a chance.
It does. And there was, all right. I guess I don't agree with you. There was a request to October 28th to change the release conditions, and that was denied. I guess that was me from the court's docket. That's what I'm reading. And so that was considered already, and that was denied. So, and now I have these allegations from pretrial services. So, all right, Mr. Valentine, we've had difficulty with getting compliance while you're on release. We've had difficulty with getting into court. And so I am going to increase that bail amount because 5,000 apparently isn't working. And I don't know what else to do. Pretrial services supervision isn't working. And so at this stage, a 10,000 cash or bond bail needs to be posted. You're appearing on Zoom. So either post that 10,000 cash or bond bail by Friday at 3, or you're in custody by Friday at 3. So you make that decision. And then we'll have a hearing I'm gonna set this I'm just gonna set everything for that January 14 day. So that we've got everything together. What time that is, but you either, as I said, 10,000 cash or bond bail to be posted no later than 3 o'clock on Friday the 20th, or you're in custody by Friday the 20th at 3, no later than 3. But we'll set this hearing. The next hearing will be January 14th at 2:30. It's a pretrial. So, any questions about your obligation there?
Yes. What are the nature and cause of these charges?
Driving under the influence. You're charged with and driving while spending the 3rd degree. The complaints are in the court file.
And what is the criminal jurisdiction like? What's the nature of the causes? Is it under admiralty jurisdiction or common law jurisdiction? No.
Washington State, RCW 4661. Violation of the state law. You're in Thurston County District Court, which has jurisdiction over you, as it's alleged to have occurred in Thurston County.
But I'm asking, what's the nature and cause of the charge? Is it under a common law? Is it under common law or admiralty?
It's under Washington state law.
The only reason I know what you're even being charged with is because the judge literally put it on the record and spelled it out for you. A DUI from 2021 and a second DUI from 2023, the one that was filed, dropped, and then refiled. And you still haven't even been arraigned on yet, Dot. So if she hadn't explained it plainly in open court, then how exactly are we supposed to know what you're facing? Because it sure isn't coming from you. You're standing there acting confused. While the judge is doing the job, you keep pretending nobody's doing.
And you can put it to writing if you think there's something more. A bill of particulars might be something that would be useful to you to send to the prosecuting attorney's office. But
I requested a bill of particulars. I've requested a bill of particulars, and I've requested the case transcript, and I've gotten neither.
Yeah, it's not going to be transferred. There's nowhere to transfer it. You're in the correct jurisdiction here in
I said
Thurston
a
County
case.
District Court.
I said I asked for a case transcript and a bill of case transcript and a bill of particulars, and I still haven't gotten it.
All right, we'll follow that up with the prosecuting attorney for the bill of particulars, and then the transcript. That would be from the court if you wanted an audio recording of the proceedings. All right,
Still haven't
so.
made clear the nature and cause of the charges, ma'am.
All right, well, I think I have. So you're to turn yourself into Thurston County Corrections no later than tomorrow by 3 p.m. or you can post 10,000 cash or bond. We'll have our next hearing January 14th, 2:30. And you stay clean and sober and law abiding, and you're still on pretrial services supervision if you're out of custody and you comply with them.
So is the prosecution under common law or under admiralty?
We're not going to go in circles here. You have
I'm
an
just asking
obligation
you
to
to,
be.
I'm just asking you,
I
as
understand.
my
I've
right. Is it
answered.
not my right to know the nature and cause of the charges?
Yep. I've answered
so-
you, Mr.
so
Valentine.
which one-
I'm not going to go in circles. You're in custody by Friday or post 10,000 cash or bond. We'll see you January 14th. That's all for today.
So why can't we go back to the original release conditions?
I've already made that ruling, sir.
And it was a void ruling. It's a void judgment.
So long, Mr. Valentine. We've talked. Be in custody by Friday or post your 10,000 cash or bond. We're done here.
So you're not going to honor your oath to
We're
uphold
done,
the
Mr.
Constitution.
Valentine. I'm honoring my oath, and I've done exactly what I'm to do by state law and Constitution.
You haven't made
simply
clear the
disagree.
nature. You haven't
We're
made
done,
clear the
Mr.
nature and cause of
Valentine.
the charges, ma'am.
Please mute Mr. Valentine. I don't want him to say something that would be untoward for him. So we're done, Mr. Valentine. Turn yourself in by Friday or post your bond.
I have paperwork in the office because I went back to talk to her. I'm so sorry. I couldn't get it to scan. I think I tried to tell Heather, but if we can adjourn for a couple weeks, I'll get everything sent over.
All right, if we have nothing today, she's gonna stay in custody.
Well, we have the paperwork.
No, I don't have anything.
Can we have her come back next week?
Yeah, from the jail.
Yeah, please say something.
You
ma'am.
didn't send over to the department.
I sent it over to my other agent. He has it all.
She said,
And I did send it to probation, ma'am. I have a job. I just started last week. I'm done a very good path right now. Please don't put me in jail.
Ma'am, you're ordered to test,
Can I
and you are
explain?
not doing that. You haven't been doing it since you've been on bond,
Can
actually.
I explain, ma'am? Okay.
I'm sick of your explanation.
I'm sorry.
to be
I'm
honest.
very sick. I have doctor's notes. There's doctor notes in there. I had surgery. They just took my other cast off and gave me a
she
removable
couldn't
cast
test because she had,
because this hand's paralyzed, so I
And-
couldn't drop with the other cast.
she just
So-
got
I'm
a
sorry, what?
Okay, let me talk. She had a regular cast on. She just got a removable cast, so she couldn't test.
You can't test because you have a cast on your arm?
She said she had a regular
I
cast
can't
on.
cup. I'm sorry, ma'am. I can't cup the cup with this hand with the other cast on, and this hand's paralyzed. So they gave me a removable cast, and I talked to Mr. Levitt, and as soon as I removed it, I went immediately in and dropped. I've been good on my tether. I'm on a GPS tether. I'm not trying to run from nothing. I'm trying to clean up my life and get my life together. I got a real job. I'm not on Social Security no more. I didn't. When I did the assessment, I couldn't control the time frame that she got that into you. And then when she did the assessment over the phone with me, she was off work last week until today. So that's why my appointment is at 2:00, ma'am. I'm not trying to violate nothing. I'm trying to get my life together and do good.
They have hats that they use when people can't use the cup.
Well, they didn't say nothing to me. I asked Mr. Levitt if he could mouth swab me, and he said that's not what the judge ordered. She ordered urine tests. I even asked, is it Lynn Schroeder? I even brought it to her attention to Community Care Corrections. I called. I said, can they start mouth swabbing me, or can he come to my residence or whatever, so I don't get violated? And they said no. The judge ordered urine screens. I inquired about it, ma'am. I didn't want no violation. I'm doing so good in my life right now.
Buckle up, guys. Today we're watching a defendant scramble in real time as the judge makes it crystal clear. No paperwork, no progress, and she stays in custody. She pleads for more time, blames scanning issues, and insists she's working and doing good. But the judge is done with excuses. She was ordered to test, and she HASN single quotes T dot.
Ms. McDuffie, what would you like to say?
So first of all, just so that Ms. Law is aware, I don't think she understood what the court just said. They have hats when you can't use the cups. A hat is a fairly large plastic, wider container that fits over the seat of a toilet so that there's no cup necessary and the urine goes directly there. We're still talking about urine tests, but that's
I didn't know that. Tell me.
Ms. Law, now is not a good time for you to say anything, plus I'm talking. That is something that they use when people aren't able to use the cups. I'm saying that just so that she understands what that is, what it means. Next. I don't know when Ms. Law was in touch with her tether agent. What I don't understand is how we managed to get a report from Agent Levitt, at least dated February 8th, that simply has missed tests, positive tests. Usually the reports that we get are pretty detailed with narrative if there's been communication with the defendant who's under a testing order when they say things like they have an issue, aren't able to test because of this reason. It doesn't say unable, missed, it just says missed. There's notes from fall of 2023 that have commentary about the things that Ms. Law explained to the agent and to community corrections regarding doctor's notes, not able to provide samples, car trouble, provided pictures of flat tire. But all of that evidence of communication is missing. All we have between basically then and now is just missed tests. It doesn't reflect any conversations with Agent Levitt. I'm not saying that she did or didn't, but I'm saying it looks awfully different from when we've had that evidence before. I don't know if she just contacted Agent Levitt today or in the last 2 days. I'm very confused about why there's proof of prescriptions coming in today. Again, I'm not speaking as to when Ms. Law contacted her attorney, but there's a whole lot of last minute shuffling of papers and things and explanations coming in when the consequence, she had a jail wreck, I think, the last time. So Ms. Law knows that her history in this court with her extended failures to appear with the testing issues, Ms. Law knows that she doesn't really have any room to be making mistakes, and we all make mistakes and none of us are error-proof, but she knows that there's not any wiggle room here and that she's got to be in extremely good touch with everybody, with her attorney, with her agent, with the court, to do whatever she can to make sure we have all the information that we can get. I believe Ms. Law is having a difficult time. I know that she does have health issues, but I'm missing an explanation, and I can reach out to Agent Levitt right now. If I had known that we were going to come back from that breakout with no progress, I would have done it then. But I can reach out to Agent Levitt and ask him to pop in and tell us what he knows about this situation and if he's gotten any contact, at least since this report came out, for some clarity. But other than that, I'm not at a loss as to why we're here in this situation right now.
Can I talk, ma'am?
No, I was gonna ask if I may.
Okay.
If I may respond?
You can explain why we're in this position right now?
No.
Say whatever you want to say.
Just that since I do have the paperwork, I would like a week and for Ms. Law to stay out to get proof of the assessment.
I heard that part already.
Okay, nothing new.
Can I please talk?
I don't think we have anything new.
I do. I have an explanation for what she just said to me.
Ms. Law would like to make a comment.
Ms. Law, if you're repeating the same thing you said already.
I'm not.
Ma'am, don't talk over me.
I'm sorry.
If you're repeating the same thing you've said to me, it is only going to make your situation worse.
No, I want to respond to this lady on
If
TV.
it's something you've said already, it will only make your situation worse.
It's not, okay. when I called and told Mr. Levitt, nobody never told me about the hand.
Okay, you
or
did say
whatever.
that.
But there's another
You
thing,
said that
I have
already.
proof in my phone right now. You have to walk me out to the car, my conversation through email with Mr. Levitt, letting him know about me not being able to drop because of the cats and stuff. I did communicate, he did respond back. It's all through email in my phone.
Did the court want me to see if he can come, Your Honor?
No, I don't. Thank you.
Mhm.
You didn't want to bring the phone in here. Of course you can't. You brought it in.
From here, the prosecutor steps in and quietly dismantles the story. They explain the testing options and point out the report only shows missed, with none of the detailed communication the court usually sees. The judge warns her not to talk over anyone, but she keeps pushing back, claiming she emailed her agent, and no one told her about alternative, each interruption tightening the pressure.
This is what I'm going to do. I'm going to adjourn this hearing until Thursday. I'm going to give you a chance to get your documents in. It's not your fault that your attorney wasn't able to scan them and get them over to the prosecutor. If you don't show up here, or if you don't have proof, like you said you do, from Hagira, or proof that you actually have these prescriptions, I know there have been some in the past, I'm going to put you in custody, ma'am.
I understand that, ma'am, and I will have all of that. I'm gonna have them.
I'm no longer playing with you, Ms.
I understand that, ma'am, and I'm when I go today and sign the paperwork, I'm gonna ask her to fax it right in front of me or email it, whatever she has to do to probation. I'm not trying to hide nothing. And I will be here. I'm on a GPS tether.
2:15, 4:11 a.m. in person again. You need to be in touch with your attorney before then to find out whether you want a hearing on these things or not.
Okay, well, I didn't get a phone call from my attorney till the weekend, so I didn't know, and that's the only contact I've had since we've been in court on Zoom. Right, I called you, I told you I had all this stuff and I have a job and all that. And then you called me on the weekend. That's the only 2 times I've talked to you.
Okay, that's true.
We'll see you on February 15th at 11.
Thank you.
Thank you, ma'am. Thank you for understanding. Okay, I didn't know because they did that where you couldn't bring your phone, so I left it in the car. But I keep everything for proof. Can you get my paperwork, please?
Yes, I'm with you. Yeah.
Thank you, guys.
She has a notice for you, ma'am. Wait one moment.
You can go ahead and walk with
I'm sorry, what was that?
Come on here.
Ma'am, go out there. I've got a piece of paper to give you, so stand by.
Okay.
Thank you.
The judge finally lays down the line. The hearing is adjourned to Thursday, but this is the last chance. Bring proof of prescriptions and the assessment, or she goes into custody. No more games. The defendant agrees, promises to show, and tries to gather her paperwork as the court wraps up. Like the video, subscribe to the channel, and we'll see you in the next video.